Okay, let's start. Okay, dear, let's start. No one is watching this video. Just to the session and point out the syllabus of the DHAKA law. So what exactly the LLB program structure? What exactly the subject matter? Which subject are focused in this regard? That should be focused here. So the first of all, we have to discuss in terms of the legal system and methods. And then the criminal law, contract law, public law, and land law, law of tort, jurisprudence and legal theory. So if you want to be a barrister in future life, you must have knowledge in these subjects. European Union, EU law, and not only that's the administrative law, civil and criminal procedure, and the commercial law, company law, criminology, evidence, family law, history of English law, and international protection of human rights. However, this is the labor law and public international law, conflict of laws. And not only that, the intellectual property law. So what exactly the intellectual property? In terms of the trademark, this is the patent, copyright. So what exactly in terms of the trademark case law, SEC versus Medical Limited, that the parachute well is what exactly the infringement of trademark. This is the highlighting approach. So how can you actually understand this is the conflict of laws, intellectual property, succession and dissertation? Those are the laws which must be rich from the side of the students who are going to be a barrister in future life. So to be a barrister, you must have to follow the law doctor's instruction in present situation. As you know, this law doctor is the best law academy in the world. So we offer this, we offer this course designation to make the students careful about the study of laws. So how can you actually study the laws? That should be prescribed here. And today's session on point of the first of all, we have to discuss in terms of the criminal law. So how can you actually discuss in terms of that? That should be focused here. So to understand this is the systematic where the committing offenses, how can you actually, what are the elements of crime? There is a part distinction between the two. Exactly, there is the crime and offense, and the fraudal offense and non-fraudal offense, and the property offense. And for example, theft and robbery, those should be mentioned here. And not only that, the fraud case, what exactly the fraud in the cheating, So sexual offense, those are mentioned in criminal law, and the general inquiry offense and foreign crime, and then denials and defenses. So today's session, I would like to discuss in terms of the criminal law. As you are going to be a barrister in future life, you must have to follow the instruction of law doctor. At present, this is the law doctor in the whole world, which is treated as the best law academy. There is no hesitation in this regard. So let's start. How can we actually discuss regarding this aspect? So the criminal law introduction. So what exactly the preface or the introduction or the discussed made in terms of criminal law in the UK? Let's start here. So you are going to be a barrister in future life. You must have to understand. But unfortunately, we have no knowledge at all to comprehend the laws. As you are going to be a barrister in future life, but you have no knowledge at all. So to make it clear or to make it lucid or transparent to you, at first we have to discuss in terms of the introduction or the preface. So criminal law is one of the significant core subject areas required for the qualifying law degree. You have all know in this regard. So crime is a common part of everyday life. Again, please. Crime is a common part of everyday life. So this is the criminal law. The criminal law is significant. Very much significant. This subject is very much significant. And crime is around us in many forms, and it is a feature of everyday news. Most of the students will be familiar with what is offense is and what is the distinction between the two, whether this is the crime or offenses. That should be focused here. So you are the students of Bhuya Academy, and you are the students of what exactly? This is the Newcastle Academy. No matter, you have to follow the instruction of law doctor to comprehend what is law actually. So the systematic way how to study and how to prove the situational case in terms of law doctor. This is the criminal law. Oh my God, we will hear the systematic way. Wow. So no matter how high soever, we have to follow the instruction of law doctor as you are going to be a barrister in future life. Oh my God. So bail submission. Wow. This is the Bravo Media, of course, from the side of Probule. Oh my God. Okay. Okay. We will discuss in terms of the criminal law. As you are the students of Bhuya Academy or the Newcastle Academy, how high soever, you are the students of Harvard, Cambridge, no matter how high soever, you must have knowledge and you must have to follow. You have to follow the instruction. What is actually happening moment from the side of law doctor to you. As you are the students of Harvard and the Cambridge, just follow the instruction of mine how to study the laws. First of all, I have to discuss in terms of that is the introduction of criminal law. So as you are the students of LLB degree, you are going to be what exactly the barrister in future life. You need to follow the instruction, and we will offer the what exactly the splendid or the dynamic course to you to comprehend the laws actually and tracking the landmark decision to prove that. So let's have a look here. So this is the feature, this is the everyday life feature or the news in terms of the crime. And thus most students will be familiar with what is offense is. However, it is important or the significant to understand, to comprehend that focus must be placed on legal principle derived from the legislation and case law. So case law is the very much important issue here. But unfortunately, we have no knowledge at all to understand the case law. Oh my God. We of all here the systematic way, and how can we actually discuss this is the systematic way. Wow, two person is watching this video. It is very much shame for the whole nation as we have no power at all to understand this the systematic way. This is shame for the whole nation. You are going to be a barrister in future life, but you have no power to watch this video. However, it is significant to understand the famous must be placed and the case law or the landmark decision must be must be understood, comprehended by you of all. Until or unless this is not but actually helpful for you to understand the laws. And criminal liability can be imposed in many instances. There is no universal definition of crime in modern criminal law. This can change over time as a result of social and political influences. It is also important to differentiate between a criminal and a civil wrong. Well, this model covers the most popular criminal offenses, and we aim to explain and take you to how and where criminal liability can be imposed on a defendant, giving all in the depth understanding of the nature of criminal liability. But unfortunately, we have no power to understand the laws, and you are the barrister, but you have no power at all to deliver your speaking power in such a way. There are many offenses that will be discussed in the model. This is the model systematic. Just we will offer this course. Just what grabs this? You must have knowledge in this regard. How can you actually study the law? There are many offenses. So, for example, they include, for example, murder. This is the culpable homicide amounting to murder and culpable homicide not amounting to murder. So, in our what exactly? This is very much helpful for you to understand the laws. As you are the students of UK University, what exactly University of London, whatever may be, no matter. You are the student of Newcastle, you are the student of BA Academy, no matter. But you have to follow the instruction, and we will offer this course. How can you actually differentiate the legal system in the whole world? We have the knowledge, and no one is able to discuss in terms of that. You are the barrister, but you have concept in terms of you have no power at all to distinguish between what exactly the provision of laws in our country. This is the matter in which section that can be dealt. This is the 303 in our penal code. But unfortunately, UK does not take the penal code. There is separate what exactly act has been published and has been enacted by the UK government. So this is the very much important or the significant study, and we will offer this course to understand that there are many offenses. This, for example, murder, assault, fraud, and sexual and property offenses, and others. Thus, it is not possible to provide one definition that encompasses all these criminal offenses. Oh my God. Considering how each offense has its own specific elements, that the offenses, there are several offenses in criminal law or the criminal justice system cries far too long. According to the PN Duda versus P. Shivshankar and others. This is the landmark decision AIR. This is the All Indian report in 1988. This is the landmark decision, and Supreme Court 1208. This is the landmark decision in terms of the justice system in the whole world. Our justice system cries far too long. This is the highlighting approach. But UK law prescribes that the criminal law, this is the committing offense. So what are the elements to commit a crime, the offense? Not only that the federal offense and non-federal offense, and not only that the property offense in terms of this, the theft, robbery, those are the what exactly the offense. This is the fraud. What exactly this is treated in our country, this is cheating. So 415 to 420, this is the section in penal code. Unfortunately, the UK government and the UK parliament does not make any laws in terms of the penal code. This is applying mainly in the Indian subcontinent, but this is not practiced in UK. Not only that, the sexual offense and general inchoate offense and 42 crime, denials and defenses. So those are the lecture systematic way in terms of this. So what actually this is the elements of an offense. To be an offense, you must have to knowledge in terms of the elements of offense. For example, first of all, we have to discuss in terms of actus reus. So what is actus reus? In one, for an individual to be found liable for any offense, three elements must be satisfied. There must be, number one, there must be guilty conduct by the defendant or the accused, actus reus. This is treated as actus reus. Oh my God. And the second one is the defendant or the accused must have a guilty state of mind. This is treated as the mens rea. But the codified law actually may be actually codified, those, or this is the codified law may deny this aspect in terms of the mens rea, that the guilty mind. And third one is that there must be no valid defense. So there must be valid beyond reasonable doubt. In later chapter, it will be discussed, and we will offer the course how to study the laws and tackling the several landmark decisions in the war. You are the students of Harvard, you are the students of Cambridge, no matter how high soever. You are the students of America or the Canada, and not only that, what exactly the Mars. This is the Mongol Groho, Nakotru, Gohonakotru, all things, and everywhere. What exactly this in the moon. You are the students of the moon. No matter. You can easily understand the laws. No matter. So the strict liability offenses, for the example, but in every case, the actus reus must be proved before the conviction can occur. Although in most cases, a defendant or the accused is required to do something in order to satisfy the actus reus. So what exactly the meaning of actus reus? Situation where this is not the case will be discussed below. Additionally, in certain circumstances, the actus reus requires an additional factor to exist or some specific consequences to follow in order for the actus reus to be established. Under Section 18 of the Offences Against the Person Act 1861, this is the act from the side of the UK Parliament. This is not found, but unfortunately this is exactly the thematic approach under Section 18 of the Offences Against the Person Act 1861. For example, the defendant's action must be owned or cause grievous bodily harm to the victim. The act reus, this is the systematic word. The act of assaulting the victim will not be sufficient to satisfy the actus reus without this particular consequence. And the distinction is described as being a conduct crime or result of a crime. Oh my God. Further example can be found under Section 1 of the Criminal Damage Act 1971. This is the Criminal Damage Act in UK. So we will offer this course to understand the laws. So you are the students of Bhuya Academy, Newcastle Academy, every sector. You are the students of the moon, the Mongol Groho. You must have knowledge in this regard, how to study the laws. Unfortunately, we are the students of law. We have no power to understand the laws, and delivering process is very much poor in nature. A person who, without lawful excuse, destroys or damages property, belonging to another, intending to destroy or damage any such property, or being reckless as to whether any such property would be destroyed or damaged, shall be guilty of an offense. So there is a distinction between offense and crime. Well, the actus reus of the offense is the destruction of or the damage of property which belongs to somebody other than the defendant. It is the result of the defendant's actions that satisfy the actus reus rather than the actions themselves, with the additional circumstances being that the property destroyed or the damage belongs to somebody other than the defendant. As you are the students of Bhuya Academy and the Newcastle Academy and the Harvard student, yes, Mr. Kobe, just follow the instruction. How can you actually identify the elements of criminal law? First of all, we have to discuss in terms of the actus reus and the mens rea. What exactly the mens rea? This indicates the guilty mind, but the codified law may deny this aspect. There are several landmark decisions to understand that. Not only that the conduct. What exactly the conduct? Some action that result in damage to property. Conduct must be taken into consideration by your CPU. And circumstances, the property belongs to the state versus Anjwara. This is the landmark decision from the side of the, what exactly in our country. The property belongs to somebody other than the defendant. Result, what exactly the result? The property is damaged or destroyed. If this offense is contrasted with the offense of rape, Section 1 of the Sexual Offence Act 2003. Oh my God, this is the Sexual Offences Act in UK. So you are the students and you are going to be a barrister in future life. You need to follow the instruction of Lord Chow. So in this offense, the contrasted with the offense of rape, Section 1 of the Sexual Offence Act 2003 provides that how can we actually, the person commits offense if he intentionally penetrates the vagina and thus mouth of another person's be with his penis. B doesn't consent to the penetration and A doesn't reasonably believe that B consents. All that is required for the actus reus to be satisfied in this context is that the penetration with a penis occurred. The victim did not consent and the defendant is therefore the conduct of the defendant that satisfies the actus reus. No particular result is necessary. To understand the actus reus, this is the systematic way of the penetration, what exactly the penis towards the what exactly the vagina. So examination consideration, what exactly the examination consideration in this regard? In all circumstances, it is essential that all elements of the actus reus are satisfied. This includes the defendant's corner. Mr. Kobe, please. You are, what exactly? hampering the systematic way that the lecture system. Just follow the instruction. And how can you actually discuss as you are going to be a barrister in future life? So to be a barrister, you must follow the instruction of mine. In future life, you are able to cut a good figure. Well, write down what I delivered to you. But why you are saying in such a way and we're shouting movement here? Okay, just follow the instruction of mine. All that is required for the actors, yes, to be satisfied in this context. What do you mean by that very aspect? You have nothing, you have no knowledge at all. Okay, no problem. Let's start. So the examination consideration. So those are the discussed made, but we have no power at all to prove that. Now we would like to discuss in terms of the how to proving approach, statutory theory and the examination consideration. So the case law prescribe in this regard that the assumption of care for another. The Children and Young Persons Act 1933 doesn't extend beyond those of the age of 16 years, and therefore no direct obligation is placed on a parent to care for an independent 18-year-old child or versus Shepherd. This is the landmark decision 1862. So this is the UK case law, the famous case law. However, two important judgments highlighted in the approach in taken to the respect of what the care is assumed over an individual who is over the age of 16. So this is the landmark decision. To understand this law, you must have to follow the Mr. Kobi. To understand the laws, yes, you are the students of blah blah blah. This is you are the student of Harvard, Cambridge. No matter. This is not the fact. You're nothing in our society. You're the barrister. So what? You have no power at all. Just you have to, what exactly? You have to submit your approach towards the code or before the code in our country. There is no option to deliver your speaking power in terms of barrister in our country. All other practitioners are treated as the advocate that the code prescribes in this regard. So don't share what exact the moody approach before me. Okay, let's move. In the case law, this is the R versus instant 1833. This is the landmark decision where Queen's Bench and the 450. This is the phase number. So in this case, it is quite clear to what takes the systematic way in terms of this, the systematic way. How can you actually discuss in terms of that? I'm in live class. So you can't, but exactly the thematic approach. You can't, but it's a call me. This is high time we discussed in terms of the UK law. As you are the barrister, you are going to be a barrister in future life, an advocate, or the renowned advocate in our country, must have to follow the instruction of law doctor. You are the students of Harvard, Cambridge, you must follow the instruction of law doctor. As you know that the best law academy in the world is treated as the law doctor. Out of this instance, what I say that just write down. 1893, this is the one Queen's Bench 450, this is the phase number. So what happened exactly in that very case? That should be focused here. So the case law in instance, the defendant lived with her aunt who became ill with what excel say gangrene. I don't know the pronunciation of that. The aunt was unable to feed herself or to seek medical help personally. The defendant didn't feed the aunt, nor did she seek any medical help for her, despite remaining living in the aunt's house. And eating the aunt's food, the defendant was convicted of the aunt's manslaughter. Oh my God. It was considered that the defendant's neglect of the aunt had facilitated the aunt's death, whilst the relationship between the aunt and niece differed the parents and child. It could be suggested that the blood relationship contributed to the decision in instant. However, this limitation was removed in the subsequent judgment in R versus Easton and Davidson. So this is the R versus Easton and Davidson. Now this Davidson, what exactly the Davidson 1977? This is the, what is the Queen's Bench 354. This is the landmark decision to understand the criminal law. But unfortunately, those who are the LLB students or the students of LLB from the side of the UK university, they have no knowledge at all to prove that situation. You're nothing in our society. The two defendants were not married. So this is the landmark case, R versus Stone and Dobinson case, 1977. This is the highlighted matters or the famous case law in terms of that the two defendants were not married but lived together. Oh my God, this is the concubinage from the side of the tracking approach in terms of the Roman law. This is the highlighted matter here, but lived together as a couple when they took into the house stone sisters. Funny, this is the suffered from the anorexia nervosa, but was initially able to care for herself when she went to live with Stone and Dobinson. However, when her condition worsened and became unable to care for herself, Stone and Dobinson didn't obtain medical care for her, and Fanny subsequently died. Oh my God. Both Stone and Dobinson were found guilty of Fanny's manslaughter. This is the crime, manslaughter in UK. The reasoning behind this judgment addresses a number of factors considered above. In this first instance, Stone's obligation to care for this sister could be considered to be born out of the blood relationship between them. This approach couldn't apply to Dobinson. Her liability for Fanny's death arose because she had previously taken limited steps to care to Fanny. The fact that these steps were taken imposed a duty on the defense to ensure that the steps were ultimately adequate, failing to meet the requirements under the defendant's liable, or the liability, from the side of defendant's liability. Oh my God. So examination consideration. What exactly the thematic approach from the R versus Stone and Dobinson 1977? You must have to focus in terms of this situation cases, the landmark decision in terms of R versus Evans. Several case laws prescribing made in terms of that. How can you actually study the criminal law from the UK? You must follow the instruction of the law doctor as you are going to be a barrister in future life. No matter how high soever, you're the student of Harvard, Cambridge, Oxford, no matter how high soever, you're the Chief Justice. What exactly the thematic approach, the chief advisor of the British government in a country like Bangladesh, no matter how high soever, you have to follow the instruction of law doctor, as you know that the law doctor is the best law academy in the world. So the medical treatment and the tapped every sector, we have a lot of what exactly the experts to teach the students in the whole world. And we can easily, but exactly the challenge sitting in Bangladesh, not to sit in Cox's Bazar. We have the ability. This is the ability. Okay, so the criminal law to understand the National Health Service versus Trust. So what exactly the thematic doctor to corresponds to with the paying for the patient was in the patient's what exactly the vegetative state. This is the landmark decision to understand the criminal law. The case, the liability, and how can you actually understand the systematic way in terms of actors yes must be voluntary. Must be voluntary. This is the actors yes, negligence. And not only that's the manslaughter, and not only that's the what exactly the manslaughter, what exactly the meaning of manslaughter, guilty mind, So this is the negligence or the attempt or the preparation. Those are mentioned here, that the murder amounting to murder and not amounting to murder. So the comparative study is offered to you as you are the students of UK and you are going to be a barrister in future life. You have to follow the instruction of the law doctor in future life, and this will be very much helpful for you to understand the laws. And not only that, the program prescribed in this regard the scheme 3 years, 4 subjects per year. What exactly? There is a diversity in this regard. So this is the intermediate. This is the examination 4 subject, for example, the legal system and methods. You are the students of UK law, and you are going to be a future barrister. You have to study the legal system and methods. What is the legal system in the world? There is the common law system and the civil law system. And not only that the word is the personal law, private law, and international law, public international law, or the private international law, and the criminal law. So today's session on point of the criminal law. To understand the criminal law, you have to follow the instruction, the landmark decision from the UK, Dunuku versus Stevenson. And not only that, this the R versus Queen. This is the landmark decision, the web clean case from the side of the UK. So the UK Supreme Court in this regard, and not only that the legal system in the whole world, this is the comparative study of the legal system, and not only this is the situation case in terms of the state versus Tausho. And why we are the best law? Why? The reason behind this, you are the students of UK law, you have the opportunity to understand the UK law and proportionately and comparative study of the laws in every country like Bangladesh, India, Canada, USA, Australia. There is a comparative study of laws, and that should be focused through the law doctor. For example, the legal system. To understand, to comprehend the legal system in the whole world, you must have to focus in this regard. How can you actually interpret or construe the laws, legal system, and the methods? So legal system prescribe this the civil law and the common law system, or the personal law, this the private international law, the public international law. So the international law, every sector we have knowledge. And not only that, so this is the criminal law and contract law. Criminal law will be touched from the side of the law doctor to you. As you are the students of the Harvard, Cambridge, you have to follow the instruction of us. And not only that's the contract law, the international contract law, this is the Dr. Mohiuddin Farooqi versus Bangladesh. Or not only that this is the landmark decision in terms of ETB Limited versus Chaudhry Mahmood Hassan and others. This is the 2003. This is the landmark decision. And not only this, the Qazi Mokhlisur Rahman versus Bangladesh, 26 DLR. This is the landmark. And 1976, this is the highlighting approach from the side of the constitutional laws. And constitutional laws, that the comparative study of the laws from the side of UK. There is no written constitution in UK. And not only this, but except the biggest constitution in India, and the smallest constitution in the whole world, this is the US, and our constitution is very much wrapped. This is the wrapped constitution in Bangladesh. And contract law and the public law, and not only that's the public in land law. So how can you actually the comparative study in the whole world? This is the land law, this is the 1950, this is the FAT, State Acquisition and Tenancy Act, where we find this is the system of law, record of law, and not only the Alluvian and Tilivian, the developments, every sectors, in every sectors, you are going to be adroit if you are admitted into this admission. This is the systematic organ or the platform to understand the laws. And not only that's the land law, law of tort. This the law of tort is known to you in our country, especially the Tariq Masood case with the Matir Moina. You have all know in this regard, and the CCB Foundation versus government of Bangladesh jihad. So this is the little boy. So this is not developed law in our country, this is the top law. But in UK, this is very much enriched law. So that should be focused by us to you. And not only that, this is law of trust and the jurisprudence and legal theory. So what exactly the legal theory and jurisprudence? Earlier we have discussed in terms of this several what exactly the theories or the schools of jurisprudence. For example, the historical school. What this pioneer, what exactly the proponents in this regard? Savigny, Montesquieu, those are the proponents or the supporters of that very schools. How can the law has been derived, and how the world prescribed? And this is the general principle of law, like the historical school or the sociological school or the positive school or the positivism with the pioneer. It's what exactly the I know, and you all know that's the John Austin. So, and what exactly the realist school of law, and not only the economic school of law from the side of Dr. Yunus, that the proponent or the pioneer of the 3 zeros. So we have knowledge in terms of jurisprudence and legal theory and EU law, and not only that, European Union law, and not only the administrative law. So this is the administrative. There is no opportunity to what extent fulfill the demand of damages like the civil suit, and not only the civil and criminal procedure in the whole world that should be prescribed by us, and not only that, the commercial law. The commercial law, you know, this is the bill of lading. Those are the commercial law. This is the Solomon versus Solomon. So this is the corporate, you know, this is the company related case law. And this is not only that the company law and the criminal law. See how can the Sutherland and Sigmund Freud prescribes the criminal law, see, and how can you actually study the white collar crime, and that the evidence, you know, the law of evidence, where we find this the res gesta or the res gesti and the plea of alibi, not only the test identification prior or the feeding the grant by estoppel, those are the tractings, and not only that, the burden of proof, those should be mentioned here in terms of the Evidence Act and the family law. So the family law prescribed in this regard, the Hindu family law or the family law made in terms of the Muslim family law and the history of English law, and not only this is the international protection of human rights and labor law. So labor law and public international law, conflict of law, how can laws are convicted among other, that should be focused by the law doctor to you, as you are the students of Harvard or the Cambridge, you are the students of Pre Academy, you are the students of what exactly the Newcastle Academy. You have to follow the instruction of the law doctor, as you know that the law doctor is the best academy in the world. And not only the intellectual property. So what exactly the intellectual property? So there are several acts in our country as well as in UK and in USA, and not only India, Canada, Australia, in Germany, Japan, in every China, they follow the instruction of the law of the intellectual property. So intellectual property prescribed, that's the copyright, and not only that the patent, and not only that the trademark infringement, that the violation from the side of the SEC versus America Limited in tracking the infringement of trademark and the several judgment, for example, Urejai Bakpokki, from the side of this is the shown of the what exactly the Humayun Ahmed, the writer of the what exactly the creator of the Humayun Misir Ali. So this is the landmark character in this situation, and he was the what exactly is the teacher of what exactly the systematic way and the chemistry. They have a lot of power to write the what exactly novel in this the what exactly this is the what Alif and character Humayun Misir Ali. So this is the system where they work with intellectual property law, and not only that the Bangla link and the infringement of the singing and song, this the in terms of the copyright infringement, you know, yeah, this is the systematic way to understand the intellectual property. And not only the novelty must be followed here, and not only that the succession will be touched from the side of law doctor 2 and the dissertation, and this is the extradition law must be followed from the instruction from the side of the UK Parliament. And you are the LLB students and the students of LLB from the side of the UK, and not only that the Oxford or the Harvard or the Cambridge. You must have knowledge in terms of the criminal law, and you have to understand, you have to comprehend that all the criminal justice system in the world, that they must have knowledge. You have to follow the instruction of the law doctor, as you have to distinguish, you have the ability to differentiate the comparative study of the laws. So this is the ending moment here. Today's number. This is the system, my boy. No one is watching this video, as we are lag behind. We are not adroit to understand the living media, and that's why no one is watching this video. So this is the system, my way. And how can we actually understand the UK law? Oh my God, Indrajalik Jaduko. This is what exactly the novice advocate. You are what exactly novice advocate? So novice advocate will be prescribed. So the open field is waiting for me from the side of Indrajalik Jaduko, and from the side of the MD Rabiul Islam, which This is the bail submission. How can actually the prudent approach or the adroit approach from the side of the bail submission fact that should be discussed? Yeah. So just phone me, Mr. Robiul. I will discuss and tracking this approach in terms of the bail submission approaching power to you exactly. Just finishing, and after ending this live video, you are allowed to call me. No media. Oh my God. So this is the ending situation. You are the students of Harvard, Cambridge. You are the students every segment. No media, Bhuya Academy, Newcastle, and every sector. You have to follow the instruction, and we will offer the significant course for you to get A plus or the first class. Oh, how can you actually prove these situational cases in tracking the landmark decision in the whole world or the comparative study of the laws? And that should be focused by us. No one is watching this video. This is sham for the whole nation. And as we are lag behind, and as we are not adroit in law, we are dull at law. We are not good at law, not to comprehend the laws actually. And that's why no one is watching this video. Oh my God, this is not but exactly the real picture in your country. We have no power to challenge the whole world. So we have no power to represent our country towards the whole nation, as we are lag behind, as we are very much in starting laws. So this is the ending moment. Today's number. Bye-bye.